This is part 4 of a 4-part video series dedicated to walking you through the domestic violence process. Both sides should prepare carefully for the hearing in family court. Both parties should attend the family court hearing unless they're told by court personnel that the hearing has been postponed. Neither side should take anyone else's word for it that the hearing date has been changed. Respondents can, but do not need to file a written response before the hearing. They can appear in person to respond. If the person who filed the petition does not attend, the family court judge may dismiss the case. The emergency protective order will no longer be in effect or be enforceable. If the accused person has received notice of the family court hearing but does not attend, the hearing can be held anyway. Both the accuser and the accused should take notes in advance about what they want to say so they don't forget anything. Both should gather any evidence and bring it with them, things like photographs, medical reports, police reports, voicemails, or text messages. If either side has evidence on a cell phone, that person should ask the judge's office in advance if it's okay to bring a cell phone into court. Both the petitioner and the respondent should decide before the hearing if they want to testify themselves. Both sides should consider whether they want to ask other people to testify. These people are called witnesses. Witnesses should have direct information about the case. They could be police officers or be people who saw or heard what happened. If potential witnesses refuse to come to court, they may be subpoenaed. A subpoena is a written command by the court to appear. Litigants can get a form for a subpoena in a circuit clerk's office. Anyone over the age of 18 who is not a party to the action can serve the subpoena. A subpoena lists the time, date, and location of the hearing. Subpoenas must be served in person. Once a witness is served, the person who served it must fill out a return of service document, and that document must be filed in the circuit clerk's office. Witnesses may ask for an attendance fee and mileage. If a child is a protected person in the petition, an adult should call the judge's office to see if the child needs to attend the family court hearing. No one should bring a child to court unless the judge says the child needs to be there. If a child does have to come to court, an adult must stay with the child in the waiting area until they're needed. Children cannot be left unattended in the courthouse. If you have to bring your children and have no one to watch them, please call the family court judge's office to let them know. In a domestic violence protection order case, no one is required to have a lawyer. However, people who do not have a lawyer must present all their evidence themselves. Some people may qualify for help from Legal Aid of West Virginia. To find out if Legal Aid may be able to provide a lawyer, call 1-866-255-4370. A local domestic violence shelter may also be able to give a lawyer referral. Everyone involved in the case should arrive on time and make sure they have enough time to park and go through security screening. Weapons and anything that can be used as a weapon, like a pocket knife, are prohibited in courthouses and courtrooms. Courthouse visitors should leave items like this in vehicles or at home. Upon arriving, everyone should check in with a staff member in the family court judge's office. Petitioners and respondents should not sit near each other or communicate with each other while waiting. Many family court facilities have separate waiting areas. When entering a courtroom, everyone should sit where they're instructed to sit. Anyone wearing a hat should remove it. Both the person who filed the petition and the person accused of domestic violence will be sworn in and have a chance to present evidence and witnesses. Both sides will be able to question witnesses called by the other side. At the hearing, the person who filed the petition must prove, by a preponderance of the evidence, the allegation of domestic violence. Preponderance of the evidence means that the greater weight of the evidence is persuasive and compelling enough to make a fair and impartial person believe it. If a family court judge determines that the claims in the domestic violence petition have been proven by a preponderance of the evidence, the judge will grant a domestic violence protective order. If the person accused of domestic violence did not come to the hearing, law enforcement officers will personally deliver a copy of the domestic violence protective order to that person. If an order is issued, the respondent will have to pay court costs. If the family court judge does not issue a domestic violence protective order, then the case is dismissed. If either side in the case is not happy with the decision the family court judge makes, that person can file an appeal to circuit court. That means a circuit court judge will review the case and decide if the family court judge made the right decision. An appeal to circuit court must be filed within 10 days of the date the family court order is issued. A circuit court hearing on the appeal will be held within 10 days of the date the appeal is filed. If either side is not happy with the circuit court decision, that person can appeal to the Supreme Court of Appeals of West Virginia. The Supreme Court's decision will be final. All domestic violence orders prohibit respondents from abusing, harassing, stalking, threatening, or intimidating those protected by the order. A protective order issued in one state is good in every state, so it remains in effect if either party crosses a state line. The family court judge also has the option to include other language in an order. For example, orders may spell out child custody and visitation arrangements, and a judge can use the order to award child support or other payments. Orders also can determine who has temporary possession of a car or a home. The judge will determine how long a domestic violence protective order will be in effect, whether for 90 days, 180 days, a year, or some other period of time. The person who is protected by the order can ask that it be extended for 90 days by going to a circuit clerk's office and filling out a form. The form must be filled out before the original protective order expires. If there is a protective order in effect, and one of the people involved files another family court case involving the same two people, then the protective order may be automatically extended. There is also a form for this in the circuit clerk's office. In this circumstance, the protective order will be extended until a judge enters another order, no matter how long that is. At any stage of this process, a person who is seeking protection may ask for the help of a domestic violence advocate. The advocate can offer information and support and attend hearings, but may not speak to the court. To find a domestic violence advocate, call 1-800-799-7233 or go online to wvcadv.org. Petitioners can proceed on their own without an advocate if they wish. Remember, everyone has a right to be safe and secure in their own home and with their own family. The West Virginia domestic violence process protects everyone.